العالمين والصلاة والسلام على نبي محمد وعلى آله وصحبه وعلى اتباع سنته إلا يوم الدين. بسم الله. Assalamu alaikum wa rahmatullahi wa barakatuh. Dear brothers and sisters who have come to this talk, this topic is very important. Since getting involved with this subject, I have had a lot of work for brothers and sisters who have had issues with not having a valid will, who have had issues with relatives or friends not being buried Islamically because they don't have a valid will, and their wishes have not been met by, say, non-Muslim family. So the purpose of this talk today is to give you an understanding of what is required from you when it comes to creating a wasiyah. My intention here is for you to leave with the ability to create a will for yourself, inshallah. If you have family who need to create a will, you might have elderly relatives, you might have non-Muslim friends who you feel need to create a will to cover themselves in the event of death. So what I'll do today, I will be covering the common law aspect. Brother Muawiyah, he will be covering the Islamic aspect. If any of you want to discuss the Islamic aspect with me after the talk, we can discuss the Islamic aspect. I've studied the Islamic aspect and I've studied the common law English aspect. So for this talk, I will be covering the common law English aspect. So any will that you will do after this talk, inshallah, it will be binding in England and Wales. So what I'll be covering in this short space of time is more the outline. I can't really go into the details of exactly how you word something, exactly how you attest it, exactly what you put where, but I'll be giving you the outline. So when you leave, you will understand if your family has a question, if your family wants to create a will, you can share this knowledge with your family, inshallah. And afterwards, if you have any questions, think of any questions during my talk, and then ask me any questions, inshallah, that you have regarding the common law. Okay, so the first section, which is probably the most important thing that you need to know, is what happens if you don't have a will in England and Wales. This is the law that covers where we are. So if you don't have a will in this country, you're subject to something called the intestacy laws. Under the intestacy laws, if you don't have a will and you leave assets, the government takes control of your assets and distributes it according to their will. So the government will give your assets to who they see in their eyes, basically. So if you're not married, the government will distribute it to maybe all of your wealth to your parents. If they can't contact your parents, then it could end up with the government selling your assets and it goes into the crown. That's a lot of the money that the crown has. It's in the hundreds of millions, is coming from intestacy laws. So people who do not have a will, the government has taken control of their assets, whether that be a house, whether that be a car, whether that be anything of value, the government will take control of, and they will use that, and then it goes back into the crown. So unless, if you have family, then you can avoid that, but this is a law that stands and is very strict. This law, there's no way around it. If you don't have a will and testament, a legally binding will and testament, then this law is very strict, it's enforced very strictly. So the government will decide who inherits from your estate. If one example that I want to use, because it's something that I'm asked quite a lot, is a nikah only marriage. If you have a marriage and it's not been registered in this country, it's subject to the intestacy laws. Your wife would not be able to distribute your wealth amongst your family, or it would be against your wishes. So if you were married, but you were not registered to be married, then under the intestacy laws, they would not recognize your wife as your wife, and she would not get a share, and then it could lead your children not getting a share, because under the intestacy laws, they're not your legal dependents, they're not your legal beneficiary, inshallah. So this is how a will is usually laid out. You begin a will with articles. That's how any legal binding document is constructed, with articles. So an article is basically points of the document where you give a declaration. So a declaration is within the article. So for instance, a first article of a will is usually, this is my final will and testament, I revoke any other will and testament, any other document that purports to be for my wishes, this overrules that. That's the first article, usually within a will. After that, you will have declarations. So declarations, there will be saying who your executors are, who will be the people who will distribute your assets, who will be the people who will look after your children in the event of your death, who will be the legal guardian of your children. That's where you put who will be the legal guardian of your children. You put that in a will, inshallah. It will cover your funeral arrangements, a declaration for your funeral arrangements. If you want a janazah to be in, say, Gardens of Peace or another Muslim cemetery, if you want a specific amount of money, this is where you put that. So you make it easy for your executors to carry out your wishes, inshallah. So they will have access through the will of your assets. So if you have a bank account and you want someone to be the person who collects your assets from that bank account, distributes it among your family, they will have the power to do that through the will. As it's a legally binding document, the will gives them that power to contact these agencies, such as a bank, such as if you have a house and you have the deed, the land registry. This will give them the power to sell that house on your behalf in your absence, and then distribute that those finances however you say in the will. So declarations are the main part of a will. Within the articles, there will be the main part of the will, and that's how you distribute your assets. And the last part, which is probably the most important part, is attestation. To have a legally binding will in this country, you have to have two witnesses. Witness you signing the will. Once you have two witnesses who have signed the will, saying they've witnessed you sign the will, then it's a legally binding document that can be held in a court of law, that can be used as your voice when you're not here, inshallah. So those are the main parts of a will. That's how a will is laid out, and these are the main basic parts. So if you're going to create a will, remember these four things are the most important things to you forming a will. It's an article which you begin the will with. You can begin it with Basmillah, with the Basmillah, and then you can declare this is your will in however way you want to word it. Then you have declarations which declare what you want to happen to your assets, what you want to happen to you in the event of your death in terms of your janazah, where you want your assets to be distributed, how you want them to be distributed, according to the Quran and Sunnah, according to the miraf of the Quran and Sunnah. That's how they'll be distributed, but you do that within a will. And the final part is the witness attestation. That's how you complete the will, and that's how it becomes a valid document in this country. If you don't have a will in this country, then you can write on a piece of paper saying, this is my will, but in the event of your death, that will be scrunched up and it will be thrown out. If there's any dispute, whether it's you owe someone money, whether it's you want to give something to someone who you might not be in contact with every day, because it's on a piece of paper and it's not been attested properly and it's not been worded properly, it won't be binding and it will mean nothing. So one person could, in theory, take all of your wealth if, under the intestacy laws, they have a particular place, if they're in a particular place in the hierarchy. So if you want to follow the Sunnah, which Alhamdulillah, it gives us a very set and a very clear way to distribute our wealth. It gives us a very clear way to be just to our family, to our loved ones, to make sure they get their share in the event of our death. If you want to follow that, then this is the way to make sure, to be sure that they get what you and what we believe they are owed, inshallah. So this is an example of a will. As I said, you can begin it with the Basmillah. That's not against any laws in this country. You can say in the name of Allah, and you can begin it with that. And you can mention the name of Allah, you can mention the Sharia, you can mention anything to do with Islam in your will, as long as it has an article, a declaration, and it's been attested properly. You can mention anything, you can distribute in any way you like, but you have to have these key things. So please remember this. If you have any family and they have a will, but they haven't done it in this way, please remember these key points, because this is very important in terms of how their assets, how their wealth will be shared, inshallah. So this is the beginning of a will, an example will. So it has an article here. This is the first article, as I said. So it basically makes clear that this is the final will and testament of this brother. So I've underlined here article. You make clear that the beginning is an article. If you want the will to be valid, you make very clear that what's an article and what's a declaration. A declaration usually begins with herein, or it usually has that sort of language, where you basically declare in this article, this is my wishes, and then it's been attested as your wishes, inshallah. I've underlined figure 1. That's something that when you're forming the will, you can create figures and you can create diagrams and boxes to show, to be clear who gets what and where something goes, inshallah. So I've underlined figure 1. This would be a figure 1. So this would be who your executors are. Your executors are those who you nominate to carry out your wishes and to distribute your wealth and to make sure your estate is properly managed in the absence of yourself. So here I've put 4. Under English law, you can have no more than 4. You have to nominate 1, but you can nominate no more than 4. So you can have 1, 2, 3, 4, whatever you feel will be the best way to manage your wealth. So here there's 4. You have to be clear of the name, of the address, of the postcode, and of the country they live in. These 4 things are the most important things when you be clear of who your executor is. Your executors, they are the most important person who will be mentioned in your will. An executor, he basically has the power to do anything that you have given him the right with your estate. So any instruction you leave in the document, your executor will have the power to carry that out. So if you leave any wealth, if you leave any items, if you leave, if you need something to be managed, and it's something that you would do if you were here, your executor is the person who will do that, and he would have that power to do that through being named in your will. So it's very important who you nominate as your executor. Usually the people who are nominated as the executors of a will are the spouse. So it's usually the wife if it's a man, or it's usually the husband if it's a wife. If it's not a husband or wife, it will usually be a brother or a parent, someone who is close, someone who will have access to the will wherever you put it, inshallah. So their job is to collect all your assets from wherever it is, the bank, whether it's a house, whether it's a car, to get the proceeds of those assets and to pay off any debts first. Because Islamically, you need to pay your janazah, so they'll pay your janazah first. They will gather up your assets, then they will pay for the rest of the administration of your will. So after they've collected your assets, what they'll do is they will pay your janazah. So later on I'll cover that, but you will, if you want, you can make clear what you want to be spent or where you want to be buried. So they will pay for your janazah. If you have any debts, they will pay for your debts. And then if you're 1/3, they will share the 1/3, and then the last will be your miraf from the Quran, the shares to your family. That's the last thing Islamically that is covered, and that's what your executor will do. They will spend the money they gather on your janazah, on your debts, on the shares to whoever you bequeath the gift, and on the miraf to your family and whoever is supposed to inherit from you, inshallah. So an executor, he doesn't just have any free will. He has to do exactly what you instruct him in the will. If he's not doing that, he's going against the law and he can be prosecuted. He has to do exactly what you instruct him or her in the will. So you have to be very clear, because the document gives him the capacity to do anything that you tell him. If he goes out of that, then he's going against that and basically can be prosecuted. So this has to be clear. So they can, within the capacity that you give them, they can apply the capital that they gather up for the benefit of yourself or the benefit of any minors that you have in your family, whether that be your children, whether that be minor relatives, nieces and nephews. They can apply it, absolutely, if you give them that capacity, inshallah. Some things to be careful to consider if you do nominate an executor. Small things that people miss but can cause problems down the line is if you, for whatever reason, you have some form of insurance and you have to pay maybe something left on that insurance, or you have some form of plan, pension plan, you have anything that requires payments down the line, you have to make sure that you're very particular and you're very clear in your will to your executor what the exact figures are and what they need to do to settle any outstanding payments with those sort of things, inshallah. A person who becomes your executor, they take on your debts. So when you're nominating an executor, be sure that it's someone who you can trust to be responsible with your remaining assets. If you have any debts, as your executor, they take on your debts. They're the person who is responsible for your debts. So the payment of your debts falls on that person because they're named in your document. No one else will be made to cover that. It will fall on that person. So you have to be very clear and you have to discuss with someone before you nominate them as an executor. Don't nominate someone without telling them that you want them to be an executor, because it is a very big role and it has a lot of responsibility. So the next part that I will discuss is the guardians. The guardians is basically who you nominate to be the legal guardian of your children. So I see, mashallah, some children in the building, in the room. If you're not here, who you nominate in the will is who will be the legal guardian of your children. So, in the event that there might be a dispute over the well-being and over who will look after your children and the maintenance of your children, who you nominate in the will be your legal guardian, inshallah. So, usually, it's the wife for a man, it will be the husband for a wife. You can nominate, similarly to executor, you can nominate up to 4. So, what is normally done is there will be the wife for the husband, and then he might nominate his brother or his sister. Someone else who he feels would be the best person to be responsible for the well-being and the maintenance of his children, inshallah. So the guardians, like the executors, they have the power and the capacity to apply income for the maintenance, education, and any other benefit for the children. So if your children, they might go to an Islamic school with fees. If your children go to a school with fees, the money, the proceeds that will be organized to pay for your children, that will be the priority to maintain and for the benefit of your children, inshallah. So the share that your children will get, your guardian has the right to use that share until they reach the age of 18 for their maintenance. So if you leave your children, let's say £10,000, if that's there waiting for them to reach the age of maturity, then your guardian has the capacity to use that to pay for their education or to pay for something else you feel is important for their maintenance, inshallah. So as soon as your son or daughter, they reach 18 or they're married. This is very important. It doesn't have to be 18. If your son or daughter gets married before 18, then legally in the common law, they can request that they get access to the money you've left them. So under the current law, they can't have access to what you leave them until they're 18, but the only way they can do that is if they are married. So if they get married young, then they can have access to that for their benefit, inshallah. So the beneficiaries' rights to assets, as I mentioned earlier, for the administration of the estate, they can have access to any assets that you leave behind. They have to gather it up, and then they first pay for your funeral costs, then pay for your debts, and then there will basically be no interest after there's nothing left for the funeral costs and the debts. Then they can basically distribute it how you've instructed. So that is the first thing that will have to happen. Until the administration is complete, your beneficiaries can't make a request, because under the law you have to pay for your debts, you have to pay for your funeral. So until these things have been done, until the whole estate has been gathered, then no beneficiary can make a request under the common law, because there's no way to know how much is there to be shared. So no one can preemptively or prematurely say, I want this now, until the executor has done their job and gathered up everything you've named in the document, and then you look to distribute the assets accordingly, inshallah. Things like pension funds, these things need to be organized separately from the will. Because the nature of pension funds, there's something that build up in your account, and it's something that happens over a period of time. So you need to organize things like pension funds separately. If you have a pension fund, you need to contact whoever is organizing your pension fund and say, this is what's going to happen. That you can let them know you have a will, and then they can incorporate that into the will. But these things need to be organized separately. You can't just name it into the will, and then after the fact, go to the pension company and say, this is a will. They need to be notified that you're going to have a will, and that this is how you want it to be distributed to the beneficiaries in this will, inshallah. So those are some of the rights that a beneficiary has in terms of distributing your assets. Gifts. Things like gifts. If you're going to distribute gifts, they can be revoked, deemed, which means revoked, if they're sold before you've passed away. So you might have named something in the will, but you've sold it. That has been revoked. So there's no way someone can see it in the will and then say, but this is in the will, I want to claim this because it's been in there. If it's been sold, that's it. It's been revoked. The moment it's been sold, it's no longer something that can be claimed from the beneficiaries. A lot of things will lapse. So certain items will lapse before the person who's created the will has deceased. So these sort of things that have lapsed, and it's been clear that it's lapsed, these sort of things can't be claimed by a beneficiary. There's no dispute. So it's not something. So it's something that if you have an executor, you might want to mention to them to put them at ease that anything that has lapsed, anything that has been sold, they are not liable for. No action can be taken against them for those things. Again, with a pension scheme, lump sums, they're payable if you've made clear to the pension company that you want access to the pension scheme. Once your executor has access to that pension scheme, they can make lump sums from that pension scheme for your beneficiaries. So if you have an adult beneficiary, they want their share now, then your executor can go into that pension scheme and he can use it in any way he wants, inshallah. For anybody with a business, there are very strict laws regarding business. So it's probably one of the hardest areas to organize assets if you have a business. So if you have a sole traded business, the personal representatives within that sole traded business, they will have an implied power to continue the business as usual. So if you have a share in a sole trade business, or if you have the main share in the sole trade business and it's your business, your executors will have that implied power to carry on business in your place to build up more assets for maybe your minor beneficiaries. So if you have a shop, for instance, and you die, your executor will have the right to carry on that shop to build up more assets that will eventually be given to, let's say, your minor beneficiaries, inshallah. It's the best thing is to give them an express power in the will. So if you have a business and you have in mind you want it to carry on after, you give them, let's say you can give them an express power to carry on the business, and you might put a clause in the will that when your minor beneficiary reaches a certain age, that he will take on control of that business. So it will be your job of your executor to either himself or to employ someone to carry on that business to make sure it keeps bringing in money, and then it will be something that will be passed on to whoever you nominate in the will, inshallah. So you have to give an express power. You have to name and you have to be very clear, this is what I want and this is what you have to do within the will. So another thing, it's a very important note, if you give a personal rep, whether it's an executor or guardian, if you give them that power to carry on your business and to take on your role in that business, they take on your debts. So if you have any debts with that business, that person as an individual will take on your debts. This is something you have to consider when you're nominating an executor. You have to consider if they're suitable to a number of things within administering your estate. So if you have a business, you have to think, are they suitable, or would they be okay to take on any debts that I have with this business? You have to really know that person and discuss with that person what you want from them in that role, inshallah. In partnerships, these are a lot more complicated than sole trade businesses. If you die and you have a partner, your executors will have no power to intervene in anything with the business. So with a sole trade, you can nominate them and they take over the business. They manage the business, they do the day-to-day work. But with a partnership, they can't do that. They can only take a benefit and they'll have to leave with that, but they can't interfere with the business. They can't nominate anyone to do anything with the business. That's how that will work, inshallah. A death, it would dissolve a partnership unless you've talked to your partner about you dying. So first you need to tell them that in the event of my death, I want this to carry on and I want whoever to have a benefit from this. But if you die, then it normally, if there's nothing there to say otherwise, your role in that business is gone. So you basically severed any links to that business in the event of your death if you don't have a will, basically. So the laws of residuary, it's in this country, it's similar to Islamic position. It's basically if you haven't given miraf, whatever's left after the miraf, it would go back to, if it's not been distributed to anyone from the 1/3, it would go back to the people who are eligible in the miraf. So it's similar to that in the common law, but the main difference is that the beneficiaries in Islamic law are only blood relatives. So your wife, she wouldn't, under the law of Rad, in the Islamic aspect, It's only blood who get the carryover of anything that's left. Under the English law, it's your wife. She's the top of that. If you have a wife and it's registered, your wife will be in control of that 1/3 if there's nothing, if it's not gone anywhere. So this is the main difference between the law of residuary Islamically and in the common law, inshallah. So now we're at what I consider the most important part, because from people who come to me and who have done work for, this is the biggest issue that they face. They don't have a will that's valid. So they've with the best of intentions, mashallah, they've gone and made their actions to create a will, but they don't have a valid will. It's not been attested properly. This is the biggest reason people don't have a valid will. It's not been attested. If it's not attested, you could write a 50-page will. If it's not been attested, it means nothing. It literally means nothing. So this, I think, please, if you have anyone who has a will, if you know has a will, please check if they've attested it properly. So I'll begin with an example that is of an attestation clause. So as before, you need to begin each section with an article. Articles are very important, so this has begun with an article, and it has a declaration within the article. So it says clearly that you're providing your signature to this document, you're affirming everything that's come before this attestation, and the people named in the article after this will be witnesses to you attesting this will. These are the main things. You need to have an article and a declaration that you yourself are signing this to attest the will, and you need to have an article and a declaration that you have witnesses who are witnessing you signing and attesting this will. Once you have that and it's signed, it's a valid will, and any court of law, it stands. And it's a legally binding document, inshallah. So as I've put an example here, in the sheets, on the second sheet, it has an example of what an attested will would look like. When you put the date, it might sound small, but it's very important. When you put the date, you have to write the date in words. You can't just put 190515. That's not, that can make your will invalid. So you have to write in words the date of when you are attesting that will, inshallah. And then underneath that, you will sign it with your signature, and then you will move on to the article, the last article, which is the witness attestation clause, where, as again, it will have a declaration. We testify that we've signed this and attested to witnessing the brother creating and witnessing this will. So next are a few points, because there are a number of things that will invalidate your will. A number of things, and I wish I could list every point, but time is quite short. So I tried to list the most important points regarding attesting your will. You cannot have a beneficiary to be used as a witness of your will. Anyone who's a beneficiary of your assets, they can't be a witness. If you have a beneficiary being a witness, your will is invalid. Okay, these are the things that will invalidate your will. You can have couples. You can have a married couple under the common law to witness your will. That's fine. It can be from any background. It doesn't have to be a professional, as in with passports, things like that. Usually you have to be professional. But with a will, it can be anyone. You can make alterations. This is a very important distinction. You can write on the will. You can use a pen and you can edit something. If you want to add something, if you want to add another executor to the list of executors, you can just write it with a pen. But you can't change it with correction fluid. Don't use Tipex or anything like that. If you use any form of correction fluid on the will, that in itself will invalidate the will. So you might attest it correctly, but if you just get some Tipex to change it and write over it, that means the will is invalid. Okay? These are very important points, because it's what I find people make these mistakes and then they find they have invalid wills. So it's very important points, brothers. If you remember these things, inshallah, it will be valuable to you, inshallah. So you have to have two independent witnesses present. They have to be present when you sign. So you might think it might be a simple point, but some people, they miss this. They have to be there watching you. This is technicality, but they have to be there when you're signing it, and that will make the will valid, inshallah. So your witnesses, they should be 18 years and over. You can't have your children as your witnesses. They have to be of sound mind, meaning they can't be drunk. And they have to be of sound physical state, meaning they can't be blind. Don't witness a will in a hospital. Some people, they might be on a deathbed. They create a will on a deathbed, and they think, okay, let me sign it while I'm on my deathbed. Let me get a nurse, or let me get a person next to me to witness my will. Don't do that, because the person who witnesses your will, they have to be traceable. They have to be someone, in the event that your will is disputed, that you can call on, or your executor can call on the witnesses of your will to say this is a valid will, so any dispute isn't valid. So in the event of a dispute, make sure your witnesses are someone and people who can be traced in the event of a dispute, inshallah. When you're choosing witnesses, as I just mentioned, they might be required to give evidence in court. Because anytime there's a dispute over a estate, it goes to court. The thing that breaks up a dispute in court is a will. This is the strongest tool to break up a dispute. One of the aspects of a court case will be calling the witnesses. These are the most important people in the court case. If you want that to be a strong tool in that case, the witnesses will have to first say this is a valid will. I am the witness of this will. From then on, it's quite straightforward, inshallah. And again, I want to stress this point because it's something a lot of people miss. Don't use things like correction fluid. Don't use Tipp-Ex. If you want to change it, just use a pen. You can cross it out even. You can even cross a mistake out if you feel it's a mistake and write in its place. But you can't use things like correction fluid. Don't use a stapler to attach anything. If you want to add something, you add it with a pen or you get an amendment of the will. Don't get a piece of paper and staple it to the will. That in itself will invalidate the will. Or don't fasten anything in any other way. Don't use a pin or anything like that. These things invalidate the will. So this is an example of a will where someone signed it. Basically what the person will do, they will have their signature at the top. They will have their full name. They will have their occupation, and they will have their address. These things make it easier, as I mentioned, to trace your witnesses in the event that there's a dispute. So this is an aspect of any valid will, any professionally done will have these aspects. If you want to do it yourself, include these aspects, because these are all the sort of things that are put there to safeguard your assets in the event of a dispute, inshallah. So the last thing, and it's something that if you get it professionally done, make sure you get it stamped. Because if you get it professionally done, the person who have it done, they'll have a copy as well. So they'll give you the original, they'll give you a stamp, which is a seal for their company, and it will make clear that you have the original and they have the copy. So again, in an event of a dispute, it makes clear and it distinguishes that the copy your executor has is the original, and it's been attested, as your witnesses will confirm. And then the person who created the will, the legal team, it will make clear that they have a copy, and they will be called to add added weight to the fact that it's a valid will, inshallah. So, as I put here, have it stamped. It gives authenticity to your will, and it makes clear that you have a valid will, inshallah. So that's just a simple example of what happens with any will. When you store your will, if you name any asset that has a document attached to it. So if you have a house, you have a land registration document. If you have shares, let's say I've come across clients who have BT shares. You have a certificate with shares. Or whatever kind of shares you have, you'll come with a certificate. So if you're going to name that in your will, to make it easy for your executor, you need to keep these documents together. So usually people have important documents together. So if you have these important documents together, your will then becomes a part of that bundle of documents, inshallah. Anything that you name in the will, try and keep them together, because it makes the job of your executor in gathering your assets for the benefit of your beneficiaries, for the payment of your debts, for the payment of your janazah. It makes gathering those funds, it makes it a lot easier, inshallah. So the ways that you can keep it in your house. If you have a secure place in your house, a lot of people, they store their will in a bank. I want to be clear, that's not the most, that's not a safe, that's not 100% sure way to keep your will safe, because I've had clients who put a will in a bank 20 years ago. They go to get it within the last year, it's not there anymore. So even a bank, they might change the layout of the bank, they might change location, and they might misplace the will that you've created. So I do say it's something that a lot of people do. They do put it in a secure box in a bank. But if you're happy with the security of your house, it's fine to just put it in somewhere you feel is safe, you feel is away from anyone to pick it, and that's fine, inshallah. Okay. These are things that I would have liked to have touched on, which are just a number of issues that you should be aware of, but I can't really elaborate on. Under UK law, a coffin isn't necessary. It's disputed quite a lot. Some people have tried to make it compulsory to have a coffin. Islamically, we don't have to have a coffin. Islamically, it's recommended. We do it very simply, don't have a coffin. So this is an issue. If you want to do it according to the Sunnah, where you don't have a coffin and you just want to have a shroud and be put in the ground, that's fine, inshallah. So you don't need to have any doubts or reservations about that. As I've mentioned, you have to have 2 witnesses to have a valid will. So under UK law, English and Welsh law, you can have any 2 witnesses. So it can be a man and a woman. But Islamically, you should have 2 men to 1 woman as a witness, Islamically. So this is something that we need to consider and reconcile within ourselves. We need to decide, I want to do it fully Islamically. So if you want to have 2 men because you don't want to have the fuss of bringing in a woman and having 2 men and 1 woman witness it. If you want to find 2 men, that's fine. But under English law, you can just have a man and a woman, but it's for us to decide if we're going to do it according to the Sharia, inshallah. So that's one thing to consider. After your divorce, anything that you've put in your will for your wife, it won't take effect. So if you have a marriage that's registered under the law, if you have been divorced and then that's been registered under the law, your wife, or your ex-wife, if she's named in the will, then even if she's named in the will, any assets that she would have been a beneficiary of will automatically cease, and she will not be able to get them, even if it's in the will. So even though it's a legally binding document, there are aspects that once a certain action happens, another action is enacted after that, inshallah. So if you have been married, then you get divorced, the wife that you have named in there, she will not receive anything according to the English and Welsh law, inshallah. Okay, so this is the last part, and I find before the last part, I want to mention this very important point, because it involves a lot of money. If you have a property and it's in a jointly held way, so you both have a share of that property, you both are 50-50 have a share in that property. If you have a will, you have to write in the will and you have to discuss with the other person exactly what you want to happen with that property. So you might say, I want my half in this property to go to whoever is entitled under the mirath, but you have to let the other half know that this is what's going to happen, so they can consent to that. Because under the English law, if you have a jointly held property, that surviving tenant, they will get control of the other half. So it doesn't matter what's in your will. Again, it doesn't matter if it's a legally binding document. There are things that supersedes a will. This is one of the things. If you have a legally binding document, then you need to be clear with the person that in this legally binding document that I want my half to go according to my wishes. And if they consent, then inshallah, that's okay. But if you don't make this clear in the will, and if you don't make it clear with the person, then they will automatically get control of the whole property under the English law. So this is something to be very wary about, because it could potentially mean your family entitled to mirath, they miss out on potentially a lot of money, inshallah. So this is the final slide. The value of your estate. Probate, basically, I'll explain what probate is. Probate is what the value of your estate, if it reaches a certain amount, you have to pay certain higher taxes. So if you, for instance, if you have a property worth £312,000, you have to pay a higher tax threshold, you have to consider inheritance tax, you have to consider land tax. All of these things are considered under probate. So once all your assets have been added up, and once you have a total figure, then you have to consider, or your executor has to consider whether they fall within probate. Because if he gets those assets and he doesn't pay the taxes that's liable on them, then wherever those assets have gone, the taxman will follow those assets, and it could end up with your beneficiaries being held in court because you owed a certain amount with all of those assets, and they could end up in a very expensive court case because your executor hasn't followed the probate and he hasn't paid his taxes. So you have to consider probate. If you feel you have that amount of money where it's going to be, it's going to have higher taxes, then you need to consider that, inshallah. If you have any property abroad, you have to check if that country recognizes your will. So some countries, for instance, makes it very hard to have a will. For instance, I've had a recent client who had, mashallah, 20 brothers and sisters in Afghanistan. He's creating a will, but we checked and Afghanistan doesn't recognize the will. So what is likely to happen, he told me, the family who wants to inherit there, soon as any bit of wealth goes to that part of the world, it will go along tribal lines, it will go along hierarchies, and the people who are supposed to inherit won't inherit. And there's no way within the Afghani legal system to correct that, and there's no way to rectify that. So you have to check if you have family in another country. Usually Commonwealth countries, their laws, they recognize a will. Usually Arab countries such as Egypt, such as Saudi Arabia, such as most Arab countries, they have a legal system in place where they recognize wills. But there's specific countries, they don't have any legal system, they recognize inheritance. So countries like Afghanistan, parts of Pakistan, as I found out, won't recognize aspects of a will, even if it's Islamically done. So you have to keep these things in mind. You have to check, and if you want it to be valid in that country, you have to make the steps, and you have to do these things to make sure it's valid. A notary, if you do have property abroad, you might need to get a notary stamp. What a notary stamp is, it means you can transfer assets abroad between countries. So, for instance, if you have family in a Commonwealth country and you want to transfer their beneficiary, you want to give them some their share, then you have to have a notary to make it easy to transfer anything to that country. And finally, if you have elderly relatives, or if you yourself become elderly, inshallah, consider filling out a power of attorney form. Because a power of attorney form, it gives your executor the right to make sure, or right to access to your assets before you pass away. So in terms of managing your assets, you might want to give that person access to those assets before you passed away. To do that, you need to fill out a power of attorney form. There are two power of attorney forms. One is for health, and the other is for property. So you would have to look at which part of your assets or which role you want your executor to have, but you'd have to look at which power of attorney form and you fill that out, inshallah. If you feel like you have any family who you think should write a will, maybe your parents, maybe yourself, maybe your wife, contact me or speak to me after this event. And if you need any questions, ask me. If you go to this website, this is the company I work for, alMadaar Legal Services. So if you have any questions, if this is one question, alhamdulillah, there's a team who are very experienced in this area, in trust and probate, and we'll be able to help you, inshallah. So if you either go to this website, arrange an appointment for a family member, and we can help you, inshallah. So I see I went over, alhamdulillah. If there's any questions, ask me any questions, inshallah.
Any questions? 5 minutes to have a question and answers. In regards to the issue of the will?
You mentioned about joint property.
Yes.
Yes. You automatically go back to the person joint will. Can you get to sign an affidavit or something?
Yeah, that's basically that's basically what you need to do. You need to get them to
Repeat the question so that.
Assalamu alaikum, brother. Jazakallah khair for the question. What the brother asked, he wanted to know if you have a joint property, do you have to sign an affidavit to prevent the property being automatically carried over to that joint owner? What you'd have to do, you'd have to get a formal contract. It can be an affidavit, it can be incorporated in the will. You just need to get something where you have the signature of the joint property owner, and you can keep that with the will. And once it's with the will, there will be no room for dispute, and there will be no way they can retrospectively say, no, I still want the owner of the property.
The witnesses that you get to sign a contract, what they also become deceased or
If your witnesses become deceased, then you just have to redo the contract and redo the will and get new witnesses, inshallah.
you die, your witness dies.
Oh, if what happens is you need to, once you die, unless your witnesses die at the exact same time as you, then soon as you died, that's when your wishes should be carried out. So usually your wishes are carried out within a month of you dying. So your executor will have access to all of your assets within the first 2 weeks. Maybe longer, it depends on how many people they have to contact. We have to contact a bank, the land register, we have to contact a lot of different things. But if you have a simple will, within a week, they can have access to all of your assets. And
Is it recommended to have different people to be executed?
yeah,
So
definitely.
basically,
Definitely. The brother.
everyone executing your witness.
Yes.
Crashes.
The brother asked
Then what happens?
if it's good to have different executors and different roles. What I would advise, I say there's not one thing that fits all. You have to look at your situation, because the main thing when choosing an executor and main thing when choosing administrators, you have to choose people you trust, because it's not a small job. It's people you think of and think he's responsible, he or she is responsible, and they will do this. So if you have a handful of people like that, then share it out. If you only have like 2 people, then I would advise using those 2 people for spreading all the different responsibilities, inshallah. You have to judge your own situation. Sorry.
You mentioned that if you have business, you're a sole trader, then you can pass on that business to anyone, like the children, for example. You mentioned partnerships, if there is a problem with that, but you didn't go into limited companies. Is that the same as a partner?
Yeah, limited companies. The brother, Jazakallah khair, he asked if, in terms of a business, if it's a partnership, if the same laws apply to a limited company. A limited company applies the same as a partnership. Anything with more than one owner or one shareholder, the same applies in every.
But that limited company has one shareholder.
No, that would be same as a sole trader. So the brother, good question again, Jazakallah khair. He asked if the limited company has one shareholder. That's the same rules as a sole trader. So, good question. Sorry.
A missing person, a missing person, someone is missing and his blood is going down. How long do they have to wait when some part of the family are thinking, oh, it's dead, let's go ahead, and someone says you might return? That's one. The second is if somebody becomes very sick and becomes really disabled, he doesn't have the capacity to determine anything mentally or physically. So can they go on to give the will or give it to the dead?
Yes, under English law, if someone, I'll answer the first question. The brother asked if someone, their mental state is basically that they're not very good mentally, they've lost their mental faculties. So what can you do then? Can you enact the will before they've passed away? Under English law, as I mentioned, you can have a power of attorney. There are two power of attorney forms. One is for health and one is for property. In that case, what would happen is you would have to fill a power of attorney form for health, and then it would give whoever you nominate, which I would advise is the executor of your will, to have the decisions of what happens to your property. Whether or not Islamically we can do that, because in a strict sense Islamically we wait to enact a wasiyah after death. That's the point of a wasiyah. But in terms of the English law, you can enact a will before you've died. This is something that the capacity is there. The second question,
Someone is missing.
if they're missing. If someone's missing, I would say it's a bit of a grey area, because I don't want to give advice and then leave you with just a bit of advice, but it's a very big subject. If someone's missing, they would have to be named dead. You'd have to get their name formally named dead. So usually if someone's been formally named dead, you have to make an application, say how long they've been gone. Then a government body will look into that. They will be formally named as dead. So I would say after they're formally named as dead, even if you don't see them, you can enact the will and you can carry out the wishes in the will, inshallah. Any more questions? Okay.
So in Islam, if someone doesn't need a will at all, what should be the society do or the imam?
That's my job.
That's
my next Bro asks if in Islam, if you don't leave a will behind, what happens to everything we just discussed now? And so that's why I'm here. We're here to talk about inheritance. And brother spoke about will. Like I said, if you now hopefully after you've seen this lecture, you've noticed that the will, as it relates to the Western perspective, is an open-ended thing. Relates to almost every aspect of your life. As in Islam covers so many things that you don't have to worry about. It's already covered before you're dead. In the UK system, there's so many things you have to worry about because it's not covered. And I want to say only, but generally those who are from revert backgrounds, who have had relatives who are not Muslim, and have relatives, or those non-Muslim relatives who have passed away, you actually see firsthand how the difficulties that they go through in dealing with distribution of property. Everyone claims that they deserve this and they deserve that, and families are torn apart just because it hasn't been laid out. It's literally down to what the person as what they said or did during their life. If they gave a will to so and so or nothing, it's a difficult one. But alhamdulillah, Allah's made it very easy for us. Allah's laid out a whole sharia, laying out in detail what would happen. So if we don't say anything, it's already there. So with the Prophet mentioned regards to the issue of guardianship, regards to your children, what happens to your children if they pass away and who do they go to? It's already covered. So that's not even a discussion of inheritance. What happens to your children? There's so many things that we have, which are that.
One final point regarding the non-Muslim family. One of the biggest things that I've found recently is that reverts, especially, they have faced very big problems if their family is not accepting of them being a Muslim, and maybe this is, I find it in the case of sisters mostly, is if the family is not accepting of her marriage to a Muslim man, and then she has children with that Muslim man, once she's passed, the family will want to dispute that man having guardianship over those children. So for instance, recently there was a brother from Libya. It's something he had to consider because his wife, who was English, her family were making it clear that they were going to dispute, if she wasn't around, they were going to dispute him having guardianship over those children. So this is a common thing that we need to consider. That if you are a revert and you have family who are hostile to you being a Muslim, you have to consider these things when you're creating a will, because you have to be very specific. This is the shortest way I can say this. Your will is basically your voice when you're not here. That's the simplest way I can put it. When you're not here, you can't speak. We're reminded of death a lot as Muslims, alhamdulillah. So we know the seriousness of death. When we're not here, we can't say anything else. We can't say, oh, I want this to happen. Oh, let me do this. So your will, when you're drafting a will, be very specific. This is your chance to word something exactly how you want it to be when you're not here, inshallah. So this is my advice. However you draft it, whoever you draft it with, be very specific. Don't just do it like, don't just sit down in 5 minutes, decide I want this, and this. Sit down with a pad and a pen, and then think to yourself, I want it to be worded like this. I want this to be here. I want this to be clear about this. And then you can word it exactly how you want, and it has to be respected in a court of law in this country. So that's the shortest way I can advise you, that the will is your voice when you're not here, inshallah.